Are you ready?
Yes, thank you, Chair.
Okay, let's continue.
Mrs. White?
Just to summarize at least part of the evidence in relation to the Department of Health and these two contracts. One, in regard to the what is it called, Wataka?
Correct, Chair.
Wataka, I'm sure I'm getting it wrong. In regard to that one, there was no tender at all, competitive tender at all. Is that right?
That's correct, Chair. That's the one where there was 3 quotations.
There were just 3 quotations that were actually the entities from which they were obtained were provided by somebody who was supposed to compete with them.
Correct, Chair.
That is Intaga.
Correct, Chair.
They supplied to the head of department, Dr. Nyembezi, and then she passed them on to supply chain management.
Correct,
And
Chair.
supply chain management said they obtained them. And one, there was no need for this purchase at all in regard to the 2 hospitals because the water had no problem.
Correct, Chair.
So it's a questionable transaction, to say the least, because there seems to be no need for it. There is a team or a person, a health professional within the department who wrote a report after inspecting the water and said the water is not contaminated. But that is disregarded, and a memo is, or email is written to say there is an urgent need for this plant in the 2 hospitals, and ultimately the purchase happens. And then with regard to the Oxen Taka, then an impression is created, or rather a tender process seems to be followed, but the entity that had been given, that had benefited from the first project in regard to the 2 hospitals, is given the right or opportunity to specify or amend specifications to suit their bid, and ultimately they get awarded this. But at some stage there is a payment, there are 2 payments of about, is it 500 each, 500,000 rand each?
Correct, Chair.
To the romantic partner of the MEC of the same department. And in terms of your investigation, you find out that Dr. Savoy's electronic diary reflects that he had a number of interactions or meetings or contacts with them, or there were a number of meetings or contacts that were planned in terms of the diary. And you say you found that at least on 2 occasions when the MEC of the department and her romantic partner stay at a hotel in Cape Town that is paid for by Intaga. Is that correct?
Just one occasion.
Just one occasion that's paid for by Intaga. The others, did you check or you didn't check?
We didn't check because the diaries didn't record that it was an
Yes.
overnight stay.
Okay, okay. So then there is this SMS from the MEC to Dr. Savoy of Intaka a few hours after the signing of the contract in regard to the Oxy plant, Oxintaka. And it seems to indicate that she is more concerned about the fact that Intaka didn't get its way in terms of the maintenance of the plant. And she says something like, we'll have to be more careful in the future. And then she says, maybe you should cancel the donation. So that's a summary of part of what we dealt with before lunch.
Correct, Chair.
Yeah. Okay.
Thank you, Chair. Now, Mr. White, returning to the body of your affidavit, Annexure RR4, and page 43,
Did you say page 43?
yes,
Okay.
pursuant to your investigations, is it correct that you prepared 9 separate reports?
That is correct, Chair.
And are those the reports that are listed in paragraph 56 and annexed to your affidavit marked annexures TSW7 all the way through to TSW16?
Correct, Chair. There was 9 reports and 1 affidavit prepared.
Now, some of these reports, Chair, deal with corruption investigated with regard to procurement irregularities with the same contractor in the Northern Cape.
Correct, Chair.
Chair, just so that you understand, I haven't dealt with any of that procurement irregularity because it was felt it falls beyond the terms of reference because there's no evidence of political interference or interference in the National Prosecuting Authority with prosecutions pursuant to those investigations. So,
Was it not corruption?
yes, it was corruption, but in terms of the brief that I have here and the evidence I am now presenting on the behalf of the state capture of law enforcement agencies, I haven't dealt with that in detail. I just would like the witness just to give you a broad outline of what those investigations entailed. But I don't propose dealing with them in the same detail as I have.
Depending, it's not as if we only deal with corruption, fraud that involves politicians and corruption and fraud
Yes.
that doesn't involve corruptions we don't deal with. So
No, that wasn't the point. What I was saying is that this evidence is focused, as was with regard to the Pandey matter and with regard to the Intaka matter, with the subsequent interference by the NPA.
the NPA, or you, in regard to the other one, you say there is no complaint that the NPA
Yes.
did not do
Yes.
their job.
Yes.
Oh, okay, all right.
It might be something that needs to be investigated later, but not at this stage with this witness.
Yeah. No,
in
that's
this.
fine. Let me hear about it and
Thank you.
have an idea, and let's take it from there.
So, Chair, the processes followed in the Northern Cape by the Department of Health were very similar to what happened in KZN. Only difference was the officials in the Northern Cape were different, and instead of the MEC being involved, Mr. John Block was the contact of Intaka and the person who directed what was to happen, and he was a person who received benefits directly from Intaka. So that was the significant difference. The other, so just, it was again the water purification plants and the Oxintaka plants purchased by the Department of Health. Chair, again, with regards to the water purification plants, there was no need. They created a need. They purchased 10 water purification plants for installation at 10 different hospitals throughout the Northern Cape. Chair, I went with the investigating officers in that matter to each of the 10 hospitals in the Northern Cape when we were doing the investigation, and not one of the 10 plants was in operation. So again, there was no need. So, Chair, what they had done was they'd installed these plants and had just diverted the municipal water supply through the plant in effectively a U and back to the hospital. When the plant...
So as if they were providing water that would have gone there anyway.
Well, Chair, it went through this plant in theory to be purified. When the hospital either couldn't afford the chemicals or for some maintenance reason the plant broke down, they just turned the taps that diverted the water to these plants back to their original direction, and they just bypassed the plant straight to the hospital with no detrimental effect to any of the patients or the people in the hospital. And Chair, just to show how ridiculous it was, in one of the instances they actually installed one of these plants at a hospital that was busy relocating to a different premises. They installed it while the relocation was taking place, and by the time the installation was complete, the hospital had relocated to a new building, so it was never even switched on. So that's the extent that there was never a need. So that's regarding the water purification plants. There was also issues around...
I'm sorry, what were the prices there compared to the prices paid by KZN departments?
Chair, I would have to check, but they were closer to what the Department of Health paid than to what local government paid.
Okay.
So they were
Okay.
again significant.
Okay, okay.
Chair, what then also happened was they used these cover quotes. So those two gentlemen that pleaded guilty in terms of their plea in KZN also pleaded guilty in the Northern Cape courts. But Chair, those, in some instances, those quotes, there was examples again of emails, etc., printed out, maintained, where Mr. Block was liaising with Dr. Savoy, saying he needed 3 quotes. The person in supply chain was being difficult. Dr. Savoy replied, I will arrange the 3 quotes. Intaka then, in their own records, have got copies of the 3 quotes, as well as copy of the courier waybill that couriered those quotes to Mr. Block's house. The following week, those 3 quotes, exactly the same ones, appeared at the Northern Cape Tender Board, and Intaka was appointed. So it just shows the level of interference in the procurement process and what was happening. Chair, there was also 16 dialysis machines purchased. They were distributed across various hospitals in the Northern Cape. A number of them went to hospitals that didn't have that unit in it, and as a result, there was no one to operate them. And Chair...
You mean they didn't have a kidney unit?
Correct, Chair. Apparently the idea was they were going to establish one, but the required nurses and medical practitioners hadn't been appointed. Some 18 months later, when we were doing this investigation, I took photographs of 7 of those 16 machines still in their original packaging, standing in the corridors of these different clinics. They just weren't operational. So again, purchased at inflated prices. Again, there was cover quotes. not using the same people as the Watakas, but other entities, and as a result, creating a need where there was a desperate need for this kind of equipment, but not at the hospitals they dispersed them to. Those were then all subsequently transferred to the Kimberley Hospital, but years later, only as a result of when the investigations were taking place. So, Chair, that
That's
process
just the summary.
at a high level, Chair, but because of the legal process and challenges that were happening in KZN, there was a decision that the cases in the Northern Cape would be prosecuted after the cases in KZN. So those cases are waiting for progress in KZN, and as a result, nothing from a court perspective has happened on those cases yet either. Although people were arrested, they were out on bail, charge sheets were drawn up, it's now just waiting for the legal process in KZN to proceed.
So Mr. Block's criminal trial was not connected with the same thing?
No, Chair, the case that Mr. Block was convicted on related to the procurement of renting of facilities for different departments in the Northern Cape and his involvement in that.
Yeah. Okay, so but you have got that report here, or
Chair,
relating to Northern Cape, or not really?
Chair, they're all attached to my affidavit.
Yeah.
So this morning we just referred to two, the two that related to KZN.
Yeah.
All the balance of those are also attached.
Yeah. Well, I want us to have that, but what you have told me is already under oath in your affidavit in regard to that matter.
Correct, Chair.
And it's in the reports that you are talking about. And you confirm that you stand by what's in the reports and in the affidavits.
Correct, Chair.
Okay, all right. Now, I think what we need to do is you do need to study the reports relating to Northern Cape and the affidavit, and they need to be identified. I would like to have a look at them as well. It may or may not be that we might ask you to come back and deal with them in more detail, but there might not be a need. It may be that the way forward might be to give the relevant people, implicated persons, people implicated in your affidavit and in your report, an opportunity to respond to it, and we take it from there. Because even a lot of that you are testifying about is really in your reports today, the past few days. So if we would like to come back, we certainly will ask you. But I know that we are not done. I think Ms. Wenzel is not done yet with you. But yes, thank you for that picture that you gave me about what happened in the Northern Cape.
Thank you, Chair. So, Mr. White, it's cool.
I just think, I'm sorry, I just think that it would not be right to tell the story involving Intaga in KZN without saying that it appears that they did the same thing in the Northern Cape, even if in terms of the Northern Cape there might not have been any challenges in the prosecution, but for a complete picture that might be important, because even with the trial in regard to KZN, the criminal trial, it may be important there may be references to what Intaga is alleged to have done in the Northern Cape. So there is some important connection, yeah.
Yes.
Okay.
Yes, Chair, and I will spend some time with Mr. White and investigate those more fully as well.
Okay, all right.
Mr. White, it's correct that a number of persons were implicated in your reports, were arrested, on preliminary charge sheets, and a final indictment was issued and filed in the KwaZulu-Natal High Court. It's annexed to your affidavit as Annexure TSW 17, and Chair, that is in RR1D for dog, and it appears at page 1867.
Yes.
How many accused were there?
So, Chair, there were 23 accused, of which 18 were natural persons.
And who are the natural persons?
Chair, if I could just refer to the document at 1867. The accused are listed as Gaston Savoy, Sipho Derek Shabalala, Busisiwe Muriel Inyumbezi, Peggy Yoliswa Nkonyeni, Victor Nchang.
So that, I think that is where that Y comes from. I didn't understand where the Y came from in Dr. Savoy's diary, where it says Peggy Y. So it must be coming from Yoliswa. Okay, all right.
Victor Nchangasi, Alson Sipho Siribiani Butelezi, Ronald Winston Green Thompson, Yoliswa Lulama Mbele, Fernando Prederi, Asano Romani, Donald Keith Miller, Sandile Gaboni, Michael Mabuyokulu, Beatrice Ntombinhele Shabalala, Indelihle Makonazi, Ozimbele Priscilla Bindela, Jabulani Nangalekhle Tuzi, Ian, Chair, I definitely need some help with the gentleman's second name,
Ian
Blose.
Ian Buhlebakhe Blose.
And then it's the entities linked to Intaka Holdings Pty Limited. There's Romo Investments 738 Pty Limited, Mr. Makunazi's entity. Skyros Medical Supplies Pty Limited, entity linked to Mr. Shabalala. Kaboni and Shazi Attorneys, and Blue Serenity Investments Pty Limited, an entity linked to Beatrice Shabalala, the wife of Mr. Shabalala. So, Chair, that indictment has some 54 charges. It related to racketeering, fraud, corruption, money laundering, and PFMA charges. Chair, that indictment took a long time to be prepared. There were lots of consultations, and when I say lots, I just can't even remember how many meetings there were. This investigation, the prosecutors, which changed a number of times, were involved right from the very beginning. So it was a joint effort. There was the police, PwC assisting the police, representatives from National Treasury, as well as representatives from the NPA. So we worked together and ultimately presented the evidence, and the prosecution team drew up the indictment. So this was the end result, effectively. But, Chair, that was only finalized after the, for want of a better word, the racketeering certificate had been issued by the NDPP, because this included racketeering charges, and you could only have racketeering charges if the NDPP had authorized it. And that certificate is at TSW 18, page 1945 in the same file, so directly after that. And that certificate is the one that refers to exactly the same charges that is in that indictment, and that was signed by the NDPP on the 31st of July 2011.
Then, Mr. White, Annexure TSW 20 is the plea deal in terms of which the two entities, Umvusa and Westpro, produced cover quotes to assist Savoy, which was referred to by you earlier in your evidence. Is that correct?
So that's correct, Chair. So after this indictment had been finalized, two of those two entities that did the cover quotes, their representatives, legal representatives, negotiated a plea bargain with the state.
Then, Mr. White, if we can go to paragraph 68 on page 49 of your affidavit. You say that after extensive work between you, the investigators and prosecutors at the NPA, charges were drawn up, a racketeering certificate issued. What happened on the 19th of March 2012?
So, Chair, on the 19th of March 2012, which is some 8 months after the racketeering certificate had been issued, I received an email from Advocate Dunwa. He was the lead prosecutor in the matter for KZN, and he invited me to attend a meeting on the 23rd of March 2012 at the NPA offices in Durban at 10 o'clock. I attended that meeting.
So, I'm sorry. I just want to make sure I understand this. When you say he was the lead prosecutor, did that relate to the two contracts relating to the Department of Health only, or did it also relate to the matter involving DAGA that we dealt with yesterday relating to the Department of Traditional Affairs and Local Government and the donation, or was it all of these put together?
It related to both, Chair.
To both, yes, the Department of Local Government and Traditional Affairs as well as Department of Health?
That's correct, Chair.
Okay, all right.
Now,
So, Chair, just to go back, if one looked at the indictment and the racketeering certificate, it included both. It was going to be one trial, Chair.
Yes, okay. Okay.
So, Chair, just maybe the only split was going to be made between KZN and the Northern Cape. They were going to be tried separately.
Yes.
And the reason there was lots of discussion about centralizing everything,
Yeah.
but then it was going to be in excess of 50 accused, and
Yes.
it felt it was going to become unmanageable.
Yeah, okay.
okay. Now, you refer to the email that you received to attend the meeting. That is Annexure TSW 22, and Chair, it appears in bundle Exhibit RR4 at page 1980.
Hang on. Has he completed paragraph 68? He got an email inviting him to a meeting on 23 March 2012 with the NPA at 10 a.m. in Durban.
Yes.
Mm-hmm.
I'm going to deal with it now with reference to the actual email.
Okay. Yes.
The email, Chair, is found in bundle D for dog. It's at page 1980.
Do I need to go to it?
Chair, you can listen to the evidence. It's not necessary.
Yeah.
If you could just perhaps read for the Chair what...
Well, if it's need to be read, it probably needs me to see
Okay.
it. I thought it might just be a one-liner.
No, I think it's important what he's...
What's the page again?
It's page 1980, Chair.
1980. Yes.
If you could just deal with this email, please.
So, Chair, that's a hard copy of the email that I received. You can see at the top of the page it's addressed to deploy PJ Lieutenant Colonel, to Trevor White being myself, and Clarence Jones, who was also involved in investigations, but not in this specific matter. And it is CC'd.
Was he a member of your team?
He was not, Chair.
Oh, okay.
It's then CC'd to Cyril S. Mlochwa, who was the acting DPP at the time. And it's an invitation to an NPA, an investigating team meeting on the 23rd of March 2012 at 10 o'clock, and it was in the Southern Life building. And just the part that's relevant to myself, Chair, it says this serves to inform you that you are invited to the above-mentioned meeting to be held on Friday, 23 March, which will be attended by the National Head of SCCU and the National Head of the Organised Crime Unit of the NPA. Chair, I found out afterwards when I attended the meeting that the National Head of the SCCU was Advocate Lawrence Morebi.
Yes.
And the National Head of the...
Mkhwebi, yeah.
The National Head of the Organised Crime Unit was Advocate Anthony Mosing.
What were you asked to bring to the meeting?
So, Chair, the first point relates to Lieutenant Colonel Deploy, and then the second point which says the forensic investigator, Mr. White, is requested to prepare the following. A, Usisiwe Nyambezi Company's flow of funds. B, Rome or funds flow analysis. And C, Intaka flow of funds. Chair, that...
where is that part of what you should bring? Oh,
it's in the middle, almost opposite.
To prepare the following. Oh, okay, now I see it, yeah.
And was Colonel Deploy the investigating officer?
That is correct, Chair. So, Chair, what I was requested to bring, it actually made no sense to me what I was supposed to do. I didn't know the purpose of the meeting. There was no such thing as a flow of funds for Dr. Nyambezi's companies, so I didn't know what was meant. The Rome flow of funds was just the two payments of 500,000 Rand each. So that, and then the Intaka flow of funds, I wasn't quite sure what they meant, but that diagram I've referred to at TSW 19 effectively showed at a high level. So I had that, but it wasn't, apart from that, I didn't know what else was required.
Did you then attend this meeting?
I did, Chair.
And what happened?
And I referred to it, page 50 of my affidavit in RR4, Chair, at paragraph 70, going onwards. Chair, when I recall the meeting very clearly because it was a very unusual meeting. It was a very hot day in March in Durban, and the only reason I recall that is that there was problems with the air conditioning in the building, and as a result they couldn't find a room where there was air conditioning or it was cool enough. And as a result the meeting started 20 minutes late. I very clearly recall that. When the meeting started, I referred to paragraph 71. Advocate Dunwa, the lead prosecutor in the matter, Advocate Vimbani, the head of the SCCU in Durban, and Advocate Mtembu, who was Advocate Dunwa's junior in the matter, were present, as well as Advocates Mkhwebi and Mosing, who I was introduced to at the meeting, and Lieutenant Colonel Deploy and Colonel Jones were also present. Chair, once that meeting started, it became very clear to me that Advocate Dunwa was almost a spectator to the meeting, even although he was
almost
a spectator in the meetings. Even although he was the lead prosecutor,
yes,
he was just effectively...
He was not active.
Active. He was just sitting in the meeting, and Advocates Mkhwebi and Mosing were running the meeting. Chair, when the meeting started, Advocate Mkhwebi informed us that a decision had been made to withdraw the charges against Mr. Mabuyakulu, and they just wanted to know what evidence there was against Ms. Nkonyeni as they were considering withdrawing the charges against her as well.
But wasn't that a strange question? Because if they had already decided to withdraw the charges against Mr. Mabuyakulu, one would have expected that they would have read your whole report, to say the least, and all relevant affidavits to get a full picture of the whole case.
Chair, that was what I thought. So this was a first for me in all the years I'd been investigating matters of this nature and dealing with police and prosecutors. I'd never come across this situation where on one of the accused, the decision's already made, and now they're asking what evidence is there. I would have thought they would either be asking for a very detailed briefing, or they would have already looked at all the evidence and would have specific queries about what was said. Taking into account...
So with regard to Mr. Mabuya Kulu, effectively, they were saying, we are not here to consult you about whether that decision we should withdraw or the charges against Mr. Mabuya Kulu. They're saying that decision has been taken. The only person we want to engage you on is Ms. Konyeni. Tell us what evidence there is against her.
Correct, Chair.
Okay.
So, Chair, this is after numerous people in the NPA have come to the conclusion there is cases against these people. There's been lots of presentations to senior members of the NPA at the VGM building in Pretoria, and a racketeering certificate has been issued. The matters before the High Court, Judge McLaren had been allocated as a retired judge to hear the matter because they thought it was going to take quite some time. So that was where it was at. We asked this question, myself and Lieutenant Colonel Deploy, and they said, regardless of what's happened to date, there's no evidence against Mabuya Kulu, in their view, and we mustn't waste their time with this, and we must just deal with Nkonyeni. So Chair,
I'm sorry. Did anybody, did you or Lieutenant Colonel Deploy or anybody seek to engage them on their decision on Mr. Mabuya Kulu? In other words, how did they come to say what you say they said? Was it because somebody said, hang on, how can you make that decision about Mr. Mabuya Kulu because there is evidence or anything like that?
Chair, we did, and that's where they said we mustn't waste their time. That decision's already made, and we've only got an hour for this meeting, and you've already wasted 20 minutes, which wasn't, we didn't waste it, they couldn't find a room. And we only had till 11 o'clock to finalize the discussions on Nkonyeni.
And before you proceed with the meeting, how did you receive this news that a decision had already been taken to withdraw the decision to withdraw charges against Mabuya Kulu, and that the people who were telling you about that decision to withdraw the charges didn't seem to have time to hear from you, and yet you had spent a lot of time, obviously at state expense, to do an extensive investigation on these matters?
Chair, I got the distinct impression that they were just going through a formality of being able to say we consulted with the investigators. They actually didn't care what we had to say. Because what I then said to them was, if we're going to do this properly, I need 3 days of time. I need to bring all the reports, all the annexures, and I need 3 days, and I will work through it with you systematically, almost as if we're going to court, to explain the evidence and show them the documents, etc. And I said, I need 3 days. They said, we don't want this to be a long, drawn-out process. We need to finalize our decision today, and you've got till 11 o'clock. Basically, get on with it.
Coincidentally, you have taken about 3 days to to take me through
Yes.
the matter.
So, Chair, I did do Mr. Pandey, so that would have been separate to this, so that may have been that. But Chair, if a decision is going to be made to withdraw against people where they're already before court, there's an indictment for racketeering, which is not issued very easily by the NPA, and not very often. You're now going to make a decision in less than an hour to withdraw. Chair, it just felt like they'd already made up their mind, and this was a formality. And Chair, it felt like they actually didn't care what the evidence was.
They wanted to finish and leave.
Correct, Chair.
And you say Advocate Junior was very quiet in the meeting.
Chair, to my recollection, he said almost nothing. So they,
And was he one of the NPA prosecutors or people who may have previously said there's a case here?
Chair, he was the person that was instrumental in drafting the indictment. So he'd been part of this case, I can't remember for how long, but it must have been almost a year.
Yes,
So he drew up that indictment. He did the
Yes.
presentations to his superiors in Pretoria. He
yes,
appeared in court when the people were arrested, and
yes,
he was going to prosecute the matter in the High Court.
yes.
So,
So his view, as far as you knew, was quite clear. There was a case to prosecute.
correct, Chair. But I got the impression that the prosecution team had been told to just be present, but not to be involved in the discussion. And Chair, it goes further. When he ultimately withdrew the charges in court, Advocate Dunwa, he made a very specific point of saying, I'm withdrawing these charges on instruction.
Yes,
He told me he did that on purpose because it wasn't his
it wasn't
view.
his view. Yes,
Only did it on instruction.
yes.
It sounded strange at the time, but that's what he said.
Well, it doesn't sound strange to me. You know, very often lawyers have a way of putting things when they want to disassociate themselves from it. Has Advocate Junior been interviewed? Is he going to be called?
Chair, I'm not sure if he's been interviewed, but Advocate Malotswa is going to testify today. He's also involved.
No. Will you please get hold of Advocate Junior?
Yes, I
He
will.
needs to be interviewed. If he hasn't been interviewed, he could throw a lot of
Yes,
light
yes, he could.
on how that decision came about.
Yes,
And so that we, in due course, we could have his evidence.
yes, Chair.
Yeah.
I will arrange that.
Okay.
Now, when you were told that you had essentially 40 minutes to address, which has taken a few days in this court, what did you and Lieutenant Colonel Deploy say and do?
I'm sorry, I missed that question. Is it after the meeting or is it still on the
When
meeting?
they were told they had
Or still in the
essentially
meeting?
they had 40 minutes to
Yeah,
address them.
okay.
What did you do? What did you and Colonel Deploy do?
So, Chair, Colonel Deploy was also particularly irritated. I mean, this was a matter we had worked on for years. And he made the rather abrupt statement to say to Advocate Mkhwebi, you send us your decisions in writing, the police are not part of this process. We're not going to be party to a whitewash to withdraw these charges by saying you consulted with us. You just tell us what your answer is. But Chair, what we then did was, in the time available, as best we could, we tried to explain at a very high level. They were not interested in seeing documents. So you can see just from what we've done for the last day and a half on this, you need to understand the detail in the process. So they weren't interested in the detail. They wanted to know at a high level. So, Chair, we did what we could.
What happened when the hour had elapsed?
I'm sorry, this was now in regard to Ms. Ngonyeni, because they said about Mr. Mabuyakulu, you mustn't waste their time, the decision has been made.
Correct, Chair.
Yes, okay, continue.
What happened when the hour had elapsed?
Chair, they said thank you for attending the meeting and they left.
But tell me more about what you said to them, if you are able to. You said you did the best you could do within the time available. Do you remember what you said, or is it
Chair, to my
what points you made?
Chair, I didn't make notes. It's some 8 years ago or so. But to the best of my recollection, we at a high level tried to explain that what I explained just before this morning was that the link of the two payments of 500,000 rand, we believed as an investigating team were linked to Ms. Nkonyeni via Mr. Makhonazi, that there was no evidence that those payments related to the Watakas, but in fact were paid during the period that she was influencing the signing of the contract and putting pressure on officials in the department to sign the contract with Intaka for the oxen Takas. And then we also referred to that SMS that she sent to Dr. Savoy, which I referred to just before, because that was a crucial reference, just showing her involvement in the process and where her loyalties lay. But Chair, that was, they weren't really interested in seeing how it all fitted together.
And what was their response after you had told them what you could tell them within that time?
They said they would make their decision. They didn't tell us what their decision was.
They said they would make it, so it's like they would make it later.
That was my impression, Chair.
That was your impression. And then they closed the meeting.
Correct, Chair.
Yes, okay.
So they, in fact, didn't give you any more time beyond that hour.
Correct, Chair.
What happened after that?
So, Chair, following that, I had a meeting on the 2nd of May of 2012 with Advocate Dunwa. And following that meeting, I sent her an email which is at TSW 23.
Was it a lady?
Sorry, Chair?
Did you say her? Was it a lady? I thought it was a man. Dunwa, Advocate Dunwa.
Dunwa, no, it's a man, Chair.
It's a man, oh, okay. I thought you said her. I thought maybe I had used the wrong. Yeah, no. Okay.
So, Chair, in the email I wrote following that meeting is on page 1982 in bundle RR4D.
Yes.
Chair, maybe if I could. So, Chair, if I could just maybe read the email. And I was sending.
Yeah, you can read it. That's an email from you to Advocate Dunwa.
No, Chair, this is an email from me to Freeman Nomvalo, who was the Accountant General from National Treasury.
Oh, okay.
Who was the contracting party with PwC. He was paying our fees, effectively.
Yes, okay.
He was your client.
Correct, Chair.
Yes.
He was my client, but I was working under the direction of the police.
Yes. This was on the same day.
Same day as the follow-up meeting with Advocate
Yes.
Dunwa, the 2nd of May 2012. And I say, Dear Freeman, I met with the prosecutors in the Intaka case this morning. They informed me that to date no charges have been formally withdrawn from any of the.
I'm sorry, I think we may have just spoken at cross purposes just now. When I said you sent this email on the same day, I meant on the same day as the day when you met Mr. Mkhwebi and Mr. Mosing.
No.
That's not true.
Not
You had
true.
a meeting with Advocate Dunwa at some stage, and this was on the same day.
This email, so that meeting was on the 2nd of May.
Yeah,
And following that meeting with Advocate Dunwa, I sent this email
on the same day.
on the same day.
Okay, all right. Well, is there something to tell me about your meeting with Advocate Dunwa on the 2nd of May?
So you
Or is
pick-
it contained here?
Sorry, Chair?
Is there something for you to tell me about your meeting with Advocate Dunwa on the 2nd of May, or is it captured in this email to?
Chair, it's captured in the email, Chair, but maybe the important
Yeah,
aspect.
I would like to hear what the
So that-
discussion was, because that would have been, I guess, the first meeting with him after your meeting with Mr. Mkhwebi and Mr. Mosing.
So, Chair, what happened was he informed me that the acting DPP in KZN at the time, Advocate Mlotshwa, was challenging the decision that had come out from Advocate Mokhebe to withdraw the charges against Nkonyeni and Mabaya Kulu. And he informed me that...
By then they had withdrawn the charges against... they had decided to withdraw the charges against Ms. Nkonyeni as well, by the time of the 2nd of May of the meeting.
Correct, Chair.
Okay.
So the decision had been made, but they hadn't been formally withdrawn.
Yeah, okay.
Because the
In court.
the DPP in KZN had said he's not going to withdraw the charges.
Yes.
Because he felt there was a case. And he said if they wanted to withdraw the charges, the NDPP must take his decision on review. And he said they must follow the formal process.
Yes.
So what he said was that to date, at that date, the charges haven't been withdrawn because the DPP is pushing back and challenging the decision.
Yes.
And that it needed to go on review.
Yeah.
So, Chair, that was on the second...
Well, I guess that what that meant was that the NDPP would need to review the decision to charge the two in terms of the National Prosecuting Authorities Act. I think that's the review they may have been talking about.
That was my understanding,
or to review the decision to withdraw, but in terms of that act.
Correct, Chair. And my understanding was that Advocate Mlotshwa, the DPP, wanted the process to be done formally.
Yes.
And the reason for that was he believed there was a case. He had signed all the original warrants of arrest personally himself.
Yes.
And he said, if you now decide to withdraw the charges, follow a formal process, and then come to that decision. But he wasn't prepared to just withdraw the charges because Advocate Mokhebe told him to.
Yes, yeah.
So, Chair, that was on the 2nd of May 2012.
Then you sent this email to the Accountant General on the same day.
Correct, Chair, just to update him on the status of what was happening, because everybody wanted to know what was happening with this matter.
Yes.
What then happened in July 2012 to Advocate Mlotshwa?
Chair, I referred to...
I'm sorry, I think what is necessary to just say, earlier on you were going to read this email, but you are not reading it now, and I think that's because you have basically told me what's contained in it. You told the Accountant General basically what you knew up to that stage about what was happening in the case.
Correct, Chair. So effectively telling him the status of the case, what the process was. It's been set down, Judge McLaren's being allocated, some people have asked for further particulars. So effectively updating him so he knew the process. So, Chair, that was on the 2nd of May. During July of 2012, and I referred to it at page 53 of RR4, at paragraph 79.
That is of your affidavit.
Of my affidavit, Chair.
Yes.
So, during July of 2012, Advocate Mlotshwa, who was the acting DPP in KZN, was replaced by Advocate Norco. And shortly thereafter, in mid-August of 2012, the charges were withdrawn against Mr. Mbayakulu and Ms. Nkonyeni. So, Chair, there was a number of stories at the time that it was just a rotational thing of acting DPP, so everybody was being given a chance. But, Chair, the coincidence is just uncanny that Advocate Mlotshwa refuses to withdraw the charges. It takes some months. He's replaced by Advocate Norco, and a couple of weeks later, the charges are withdrawn.
And as far as you know, when Advocate Norco withdrew the charges, the review process that Advocate Mlotshwa had said he wanted to happen, the formal process that would lead to the NDPP making a decision, had not happened.
Chair, it did not happen.
So you have an acting DPP who refuses to withdraw the charges when Mr. Mugwebi and Mr. Mosing say they should be withdrawn, and he insists that there should be a proper lawful process followed in terms of the act. Then he gets removed and somebody else takes his place, and that process that he wanted to be pursued doesn't happen, and the new person doesn't take long before she withdraws the charges.
Correct, Chair.
Yeah, okay.
And before she withdrew the charges, did she ever ask you or Colonel Deploy to brief her on the matter, ask for documents, explain the matter to her?
Chair, I was not asked, and to my knowledge, nor was Colonel Deploy.
Do you have any knowledge whether she withdrew the charges because she came to the conclusion, after looking at the matter, that they should be withdrawn, or she withdrew them in order to carry out an instruction from somebody senior to withdraw them? Because if she was carrying out the instruction, maybe there might have been no need for her to interview you or consult you, but if she was making her own decision, one would have expected that she would want to consult with the investigating officer and yourselves.
So, Chair, we weren't consulted. The time frame was very short. If one was to study the documents that are in the docket, which are the forensic reports, the annexures, and all the affidavits of all the factual witnesses, if one was to look at that cold and read it, it's going to take weeks and weeks of time. It's not going to be something you can just do in an afternoon.
Yes, yes.
So, Chair, just in respect of the time available, and considering that she was the new acting DPP, even if she spent every day working on it,
yes,
she probably wouldn't have got through all the documentation by the time she made the decision.
Yes.
So the only inference I could draw would be that it was on an instruction, just because of the time available.
And if she had taken the trouble to read as much as she would have had to read in order to arrive at a decision, she probably would have wanted to speak to the investigating officer, and you would have known even if she didn't speak to you.
I would have, Chair.
Yeah. Okay.
Now, had she read all the documents and all your reports, in your view, is it conceivable that she could have come to a decision not to prosecute?
Chair, the facts are the same facts are presented here at a high level, so there's a lot more content and detail behind that. It's just more evidence supporting what happened. So, Chair, the decision would be her interpretation of those facts, but a lot of other people in the NPA prior to that had come to the decision there was a case. So how you would come to, I know lawyers come to different decisions based on the same facts, but it appeared that the facts weren't really that important in this decision.
And when you say you made numerous presentations to prosecutors at the NPA, was that to several prosecutors?
Yeah, I can remember a couple of meetings at the VGM building where there was probably 30 people in the room where this matter was discussed. So, it wasn't, and they were senior people, it wasn't junior people that were involved. And Chair, but just the rigorous process to get to a racketeering certificate is not something that happens very easily in the NPA.
There must be a reason why the Act requires that racketeering charges be pursued only after the NTPP has issued a certificate. That's what, in part, you are talking about.
Correct.
To say that is simply because the idea is that this is a special kind of crime. And the idea is that it must have received consideration and attention of the highest officer in the NPA before anybody is charged with it.
Correct.
Yeah. Okay. Now, what do you say about Mr. Mkhwebi's and Mr. Musing's view or conclusion that there was no case against both Mr. Mabuya Kulu and Ms. Nkonyeni? And maybe I must just say that there was no prima facie case, because that's the conclusion they must have reached. At that stage, they are not looking at whether there is a conclusive case. They are supposed to look at whether there is a prima facie case which the accused must answer.
So,
in the light of the work you had done, in the light of the facts that you knew about the case as part of arising out of the investigation, what do you say about that decision or that conclusion?
so Chair, just to clarify.
And I accept that you are not a lawyer.
Okay, so that's what I was going to say.
Yeah.
So Chair, so I'm an accountant by training.
Yeah.
But
you have dealt with these types of crimes for
many years.
For around about 20 or more years.
So Chair, it just didn't make sense. So on the facts, as I knew them, that were supported by, in the most part, by documents, the decision just appeared illogical, and it appeared that it was made for an ulterior motive. That it didn't, and that was also from all my discussions with the various prosecutors that had been involved, etc. There was no legal basis, and I never saw. Actually, the other point to make is that when these kind of decisions are made, okay, normally it's not so late in the process. It's not when the person's already appearing in court and it's set down. There's normally a review done by the prosecutor normally, maybe someone more senior, and they will look at the evidence and say, you've got a gap over here. You need to fill that gap, otherwise we're going to have a problem if we go to court. Go and look for more evidence, more documents, find a factual witness that was at a meeting or was involved in some process. So it's not a decision, you tell us what you got and then we're going to say there's nothing. They would normally look at it and say, here's where you need to do something further. Now that definitely wasn't the process followed here.
And at the meeting which you attended, where Mr. Mkhwebi and Mr. Musing were present, did they ever give any reason for the conclusion that they had already reached, that there was no case against Mr. Mabuya Kulu, and they had decided, or the decision has been made to withdraw the charges against him?
Chair, they just said there's no evidence.
But did
No.
they reason that out to
No.
say what was the basis for saying there was no evidence?
Chair, they just refused to discuss it because they said the decision's already made.
Yes.
And when we tried to probe it, they said we're wasting time,
Yes.
and you've only got an hour, so that topic's closed. Now let's talk about Nkonyeni. They were not interested in discussing it at all.
Did you establish from them in one way or another at that meeting or after as to who exactly had made that decision? Was it them or was it somebody else?
So Chair, I had no interaction with them after that meeting, so there was no further opportunity to ask that question.
Yes.
But they never said, and they never said at the meeting, so I never heard whether it was
Yes.
someone else told them
Yes.
to do it,
Yes.
or whether they just did it on their own behalf.
But is my understanding correct that the way they spoke about the decision, or let me put it this way, did you get any impression whether when they said the decision had been made, that meant that they had made the decision, or was it neutral that they were not indicating who had made the decision? They're simply saying that decision has been made, and don't waste our time because it's futile to talk about it.
Chair, it wasn't clear whether it was their decision or somebody else had told them. They just said the decision's been made.
Okay, thank you.
Thank you, Chair. Mr. White, you say in paragraph 79 that charges were also withdrawn against Ms. Pindela, Mr. Tusi, and Mr. Blows. Who were they?
So, Chair, those were the attorneys that worked for Kaboni Shezi attorneys. So they were the people that had been making the payments out of the trust account. So originally they were charged with a money laundering charge. But obviously if you're going to start withdrawing charges against people further down the line, and likewise the charge against Mr. Makwanazi was withdrawn because the charge against Nkonyeni had been withdrawn. So the people on the periphery of the two MECs, the charges against them, even although it wasn't discussed at the meeting, they were ultimately withdrawn against them later.
And your understanding is that the withdrawal of charges against those people was a consequence of the decision to withdraw charges against the two MECs?
Correct, Chair.
Okay.
Now, you've told the Chair that Advocate Dunwa made a point when he was required to formally withdraw these charges in court. And he said, I'm withdrawing the charges on instructions. Did you have cause after this to discuss what had happened with Advocate Malotswa?
Chair, I did. So Advocate Mlotswa was the acting DPP that had been replaced by Advocate Norco. And Chair, I bumped into him, I can't recall, I think it was at the airport on one occasion, and I was talking to him, and he said that he believed the reason he was removed as the acting DPP was because he had refused to withdraw these charges.
And do you recall who the National Director of Public Prosecutions was at this time?
Chair, I don't specifically.
I'm sure Mr. Mlodra will tell us. Yes, okay.
He's going to testify, Chair.
Yes.
Now,
Are we, has Advocate Norco been interviewed? Are we going to get her to come here and
Yes.
explain some of the things?
yes,
Yes.
it is
Okay.
the intention.
Okay.
Could you tell the Chair after that what has happened to these matters both here and in the Cape?
So, Chair, there were a number of challenges brought, legal challenges in the case brought by Dr. Savoy and Ntaka's legal representatives. So the first legal challenge they brought was they challenged whether the words ought to have known are constitutional. And that obviously followed the process where it went to the SCA and it then went to the Constitutional Court, and the Chair probably knows better than I do, it was found that they are constitutional. But that just was a delaying process. It delayed it by almost 2 years. And in partway through that appeal process, in May of 2013, they filed notice that they were going to apply for a permanent stay of prosecution. And the main reasons for that permanent stay, apart from various others, were that the politicians had been treated differently to Dr. Savoy and the Ntaka people. So they were saying that there's not equal treatment of all the accused, and if the charges were withdrawn against the politicians, the charges against Dr. Savoy and Mr. Predating should also be withdrawn. That's one of the reasons for the application for a permanent stay. Chair, that
Is at M. Were the charges withdrawn against every accused, or was it the 2 MECs plus departmental people in their departments, and Mr. Mkwanazi only, and Dr. Savoy and others did not have their charges withdrawn against them.
So, Chair, it was against the MEC, the 2 MECs, and those attorneys and Mr. Mkwanazi, so it was them. There was also charges against, at a later point, against Mr. Green Thompson and Dr. Mbele, who were also heads of Department of Health, they were also withdrawn against. So the other officials within the Department of Health, as well as Mr. Shabalala from Provincial Treasury, as well as the people from Intaka, those charges stayed. So some were withdrawn, and Chair, if I understand, there's either 11 or 12 accused that are still before court.
Did you ever get a chance to apply your mind to the fact that charges were withdrawn against some and not against others? And were you able to understand the basis of the withdrawal in terms of evidence to say, well, maybe I do understand a little bit about so-and-so, the charges being withdrawn, but I can't understand the withdrawal against so-and-so and so-and-so, or I can't understand why, if there is no case against so-and-so and charges against him or her are withdrawn, why that one remains.
So, Chair, that's a lot of that, what's left doesn't make sense. But, Chair, what's happened in the process is NPA has changed the prosecutors in the matter. So Advocate Dunwa is no longer involved.
Who is now involved?
So, Chair, Advocate Bimbani from the SCCU in Durban is currently heading up a team, and there are new prosecutors allocated. But, Chair,
I want you to finish what we were dealing with, namely that which you thought didn't seem to make sense about withdrawal and not withdrawing. I thought you had not finished
Chair,
what you were telling me.
It's currently not clear exactly which charges the accused that are left still face. So the state has withdrawn charges against some of the people that got the alleged corrupt payments, but I don't know what amendments have been made to the charge sheet, because it's just not proceeding because of this permanent stay application that has been floating around for some 6 years, Chair.
Yes, I would like you, if you haven't done so, to look at which charges were withdrawn against whom.
Yes, Chair.
And does that withdrawal make sense if the charge against so-and-so is not withdrawn?
Yes, Chair. And I will address you on that.
So I would like that to be looked at
Yes.
in depth.
Yes,
Yeah.
Chair.
Okay, all right.
So, Chair, even although the permanent stay application was initially, notice of motion was issued in May of 2013.
Yes, I was about to ask you, why, do you know why it's taking so long to process a review application,
So, Chair,
to process that permanent stay application?
Chair, there seems to be a reluctance on both the part of the state and the accused to set the matter down. I now understand it is set down for in the next couple of months. I think it's sometime in March of this year, so almost 7 years later, it's now finally set down. But, Chair, what this has done, it's effectively sterilized the whole prosecution, both in the KZN and in the Northern Cape, because nothing has happened.
Ms. Wenzel, I'm interested in the Commission examining what has been happening in regard to that application from the time it was launched. What has been done, by whom, with whom, up to now,
Yes.
so that we can see if there is a case to say people who were supposed to make sure that it was processed quickly didn't do their job, because I can understand if the accused who brought the application don't mind if it's not pursued, processed quickly. But I wouldn't understand why the NPA, if for argument's sake, the accused were not acting diligently in pursuing it, why they themselves wouldn't do that. So
Yes,
I
Chair.
want to know what has happened. The NPA has always had either a head or an acting head over the years.
Yes.
How can that application stay pending for 6 years?
Yes, Chair.
Or was this another way of letting this matter go away?
Yes, Chair.
So, Chair, while there was this whole nothing happening, I was then approached sometime in 2017, can't recall exactly when, by Advocate Van Barney, who now said she was heading up the prosecution and she had a team, and she wanted to consult with myself relating to the evidence with the new prosecution team. Chair, because I'd had no involvement in this matter for some 5 years, I went back to National Treasury and said, are you prepared to appoint me to consult with these people? The National Treasury said they weren't prepared to pay further money for something that didn't appear to be going anywhere. And if the NPA wanted to consult, then the NPA must pay. I went back to the NPA with that message, and they subsequently appointed PwC on the 13th of December 2017 and said, right, you're appointed, we want you to brief us, and we want to consult in the matter. Chair, the first consultation took place some 6 months later, on the 12th of June 2018.
Well, there might not be any connection, but it's interesting that attempts to get going on the matter started or resumed in 2017, when there were to be certain changes in the political landscape of the country.
Chair, lots of these things happen. If one draws pictures between the dates and happenings, they
Yes,
overlap.
it's something we have got to look at, because decisions of the NPA should have nothing to do with who is in what position where. But part of what this commission is doing is looking at to what extent the NPA and other law enforcement agencies may have allowed themselves to be influenced in regard to certain matters. And we need to look and remain open and look at everything. Maybe it's got nothing to do with that, but we must remain open and look at all possibilities. Yes, so the NPA appointed you to...
In December of 2017,
Yes.
to consult. The meeting took place on the 12th of June 2008. Advocate Van Barney was present, together with 3 new prosecutors that had never been involved in the matter before, as well as Lieutenant Colonel Deploy and Mr. Janssen van Vuren, a manager in my office that had assisted me with the matter originally. Chair, the prosecutors were totally unprepared for the meeting. They did not have any background other than what they'd seen on TV, read in newspapers, or heard in corridor talk. They had not read anything. I then asked them, have you read the reports? They said, no, you must tell us about it. Chair, with respect, I was fairly
You were annoyed.
yeah, annoyed is probably the right word. Because now we're going to have a 2-day consultation and they know nothing about the matter. So I said to them, it's not my job to read the report to them. So what we ultimately agreed was we would give them an overview. So similar to what we've probably done today, Chair. We spent the better part of the first day giving them an overview of what the case was about and who the people were that were involved. We then agreed that we would adjourn and reconvene on the 16th and 17th of October 2018 to work through what they now perceive the charges should be and the detail.
So how big was that gap between that first meeting and the next meeting, more or less?
4 months, Chair.
4 months, okay.
So it was from the 12th of June till the 16th of October.
And the lead prosecutor now was who?
It was Advocate Mbani, Chair.
Yes, okay.
So, Chair, just before that meeting was to take place, we confirmed, right, the meeting's taking place, and we were told they were not ready for the meeting. They needed more time to study the material.
Now, just to understand what was happening. Now, when you had this meeting with them, was it on the basis that they wanted to consult with you in order for them to make certain decisions about the application for a permanent stay? Did they want to consult with you so that they could make a decision, you could assist with information for them to make a decision as to whether to withdraw or to restate the charges that had been withdrawn against certain accused in KZN? Or was the purpose of the meeting, a consultation, that they could make decisions as to the way forward in regard to those accused persons against whom the charges had not been withdrawn?
So, Chair, it was the last one.
It was the last one.
So it was how this team of prosecutors was now going to prosecute the remaining accused
Yes.
against who the charges had not been withdrawn.
Okay.
So, Chair, I would have thought they would have started with the charge sheet that was currently before court. They would have crossed out the charges that relate to the accused that are withdrawn, and then you would work with what's left. But it looked like they wanted to start afresh. But, Chair, so 4 months went past, and then the meeting did not take place because they said they needed more time. So that was October of 2018, and to date the meeting's never been rescheduled. Chair, it sounds impossible, but they've never come back and said, we're now ready, let's consult.
So the NPA appointed you towards the end of 2017 because they wanted to consult with you in order to take the matter, the charges relating to the accused against whom charges had not been withdrawn, to take that matter forward. And there was a meeting sometime in 2018, and it was adjourned, and the date was arranged for a second meeting. Then that meeting didn't take place because they were not ready. They said they were not ready, and it's 2020 now. They've never come back to you.
So, Chair, relating to consulting around that, that's
Yeah.
correct, Chair.
If they've been in touch with you, it's been about other matters.
So, Chair, there was a meeting towards the end of 2019 where they wanted to discuss, one of the accused wanted to enter into a potential plea bargain, and they wanted to talk about the details around that. That's the only further consultation that has taken place.
Yes. Okay, all right. Yes, thank you.
Thank you, Chair. Chair, unless there is something else you would like to clarify, address with the witness, that concludes
You are
the
done.
evidence of the witness, yes.
Yes. No, I don't think I've got further questions. Thank you very much, Mr. White, for coming forward to assist the Commission Um, we may ask you to come back, or we may correspond with you with regard to the Northern Cape matter, or if there's an application for leave to cross-examine you, and if it's granted, there may be a need for you to come back, but then the commission will be in touch with you at that time. But thank you very
Chair.
much, and you are excused.
Thank you, Chair.
Thank you.
Thank you, Chair.
Yes, the next witness is ready.
Chair, if I might just address you firstly, the next two witnesses are going to be Colonel Duploy and also Advocate Mandiati. Chair, those witnesses are going to be led by my learned friend, Mr. Nicholson. But I just want to address you on one aspect, and that is the issue that was raised by the attorney for Mr. Ngubeleni, Mr. Maniklau, during the course of the proceedings where he...
You're referring to counsel for the provincial commissioner?
Yes.
Okay.
Now, what was said was that he had informed Mr. Nicholson that there were two cases in which his client had set out her version. And there was a very clear implication and criticism of the Commission for not having pursued that, or had a look at it, or had made any effort to find those cases. I want it placed on record that, from what I understand from Mr. Nicholson, the conversation took place in a much more oblique way, in a different context. He had no idea that what was being referred to were affidavits that had been deposed to by her relating to this very matter. Be that as it may, Chair, what has transpired is that attempts have then been made to obtain the two matters. The two matters are, the first, an affidavit deposed to by his client in an application to strike out certain statements made by Colonel Boyson in his application to have himself reinstated. The second is an affidavit deposed to by her in her own disciplinary proceedings. Now, the first affidavit was emailed to Mr. Nicholson by Mr. Maniklau last night, and I have that before me. The second was retrieved from the archives in Durban and couriered this morning. It arrived at the Commission's offices while I have been leading this evidence. I have not had a chance to look at it. So, Chair, I cannot address you as to what is set out in the disciplinary proceedings.
Well, what you have said may be construed as if counsel for the provincial commissioner criticized you. I don't know whether you intended to say that.
No.
I didn't understand him to criticize you.
No, I understood him to criticize the Commission. And also, what I wanted to correct, Chair, is that when this was said in the manner in which it was said, I publicly said to you, but my junior did not even mention this to me. Chair, that was not fair, and I need to address that. An aspersion was created that perhaps he hadn't done his job properly, and it was something he really should have told me about. But it has been explained that that didn't happen, and I just think that that needs to be publicly addressed.
No, that's fine. I just wanted to make sure that you are not understood to convey that counsel for the provincial commissioner was criticizing you or the legal team based on what he may have told Mr. Nicholson the day before. Maybe there is room to say there was some criticism, maybe mild, implied, to say, but there is a version in the public domain from my client, and we expected the commission to have been aware of that. Maybe to that extent, maybe it can be said there was some criticism, but my own impression was that counsel for the provincial commissioner said whatever he needed to say in a very constructive manner and in a very collegial manner, and sought to cooperate. That was my impression.
Yes.
I may have, I certainly expressed certain sentiments which may be seen as criticism of the legal team or whatever, but it wasn't based on, to the extent that you can call it criticism, it wasn't based on the fact that the day before you were told something. I specifically said there hadn't been much time, even if you had been told, if you were told the day before. So whatever concerns I had were based on other factors in relation to not having that information. But I think you have placed on record what you wished to place on record.
Yes, Chair, I just wanted to correct what the criticism I'd levelled at my colleague on national TV, and I just felt compelled to address that.
Okay.
Thank you.
Right. Okay.
If I can ask him to then call the next two witnesses.
Well, let's talk about the fact that we are at 20 minutes to 5. Maybe he should
to 4.
take. Or is it to 4? Oh,
Yes.
Okay. No, I looked at my watch. I thought it was to 5. Okay, there is still time then.
Yes.
Okay, all right.
Thank you, Chair.
I'm happy that there is still time. Okay.
Thank you.
So let us let him call the witness, and we can talk about whether it looks like we can finish within the remaining time.
Thank you, Chair.
I'm happy to continue until 5.
Yes, Chair.
Yeah, okay.
Thank you, Chair.
Mr. Nicholson,
Good afternoon, Chair.
good afternoon.
Chair, I intend calling Advocate Maniati. The legal team had intended on calling 2 witnesses, Colonel Deploy and Advocate Maniati. However, due to the time constraints and the fact that they are both from Durban, and both of them have planes at 7 o'clock, which means that they both need to be out of here by 5 at the very latest. I think that we may only be able to finish 1 witness.
I think what we should have done yesterday, if we at that stage thought that we would take as long as we did with Mr. White, we should have explored the possibility of starting earlier than 10 o'clock. But it may be that it wasn't foreseen that we would take as long as we ultimately took with him. Now, of course, the one concern that arises if we are not going to hear the evidence of one of them is that costs have been incurred to bring them up here. And if any one of them has to go back without giving evidence, that would mean further costs would have to be incurred some other time when they must come up. That I know that in chambers I indicated that we could continue until 5, and I've just repeated that now. but it may be that if need be, we might have to look at possibilities. Now, the one possibility is subject to me checking if I can manage, is that I sit and we deal with both of them if they can get, the one that will come after this one, will, if they can get later flights. But I understand yesterday SAA wasn't flying, so that might mean there is a reduced number of flights available. But I don't also know whether they may have commitments that they need to honor. So do you know anything about these issues that I'm raising?
Chair, with regard to the flights, we have attempted, certainly for Advocate Maniati, we have moved the flight by 1 hour. There is no flights after 7 o'clock, as I understand, because what I had suggested was we moved the flights to 8 o'clock.
Yes.
But the administration staff had come back to me and stated that they could only get a flight at 7 o'clock.
Yes.
Colonel Deploy's flight is at 20 to 7.
Yes.
So it wouldn't make any sense to move it to 7.
Yeah. Okay.
On my estimation, Chair, we may be able to conclude both witnesses in 1.5 hours.
Yeah.
If we can just see how it goes.
Maybe let's try. Let's start. Yes. Let's just administer the oath of affirmation to the witness.
Please state your full name.
I think switch off the other one. Yeah.
Please state your full names for the record.
Felix Maniati.
Do you have any objection to taking the prescribed oath? Do you consider the oath to be binding on your conscience?
I
Do you swear that then that you will give it with the truth, the whole truth and nothing but the truth? If so, please raise your right hand and say so.
So help me God.
Thank you very much. And then you can just switch on your mic. Thank you. Yes, Mr. Nicholson.
Chair, Advocate Maniati is going to deal with with one issue: his involvement in the prosecution of Colonel Madu and Toshin Pandey in the corruption matter. Advocate Maniati, do you have your affidavit in front of you?
I do.
Do you confirm that?
I'm sorry. We should admit this first, isn't it?
That's correct. With the leave of the chair,
The affidavit of Mr. Begi Felix Maniati will be admitted as Exhibit RR3 and will be marked accordingly.
I mean, that's a chair.
That includes whatever annexures there are to it. Yeah. Yes.
Do you confirm the affidavit with annexures that run from pages 1 to 29 of RR3? Do you confirm that's your affidavit?
I do. However, Chair, there is one aspect that I would like to elaborate on regarding paragraphs 19 and 22. My elaboration will not...
Hang on, before you elaborate. You do confirm that this is your affidavit?
Yes.
Okay, so now you want to talk about the contents and you have something to say on a certain paragraph, is that right?
Yes, 19 and 22, I will just add something in due course, but it will not take anything away from the
substance.
essence. Yes.
Yeah. Okay, no, that's fine. Do you want to do that when it is the right time as you give your evidence?
Yes, Chair.
Yeah, okay, all right.
Do you confirm those are your initials at the bottom of each page?
Yes.
And at page 11 is that your signature?
Yes.
Do you confirm the correctness and truthfulness of your affidavit, save to what you have just mentioned?
Yes.
Advocate Maniati, where are you currently employed?
I'm in private practice as an advocate at the Durban Bar.
For how long have you been in private practice?
This is my 6th year.
Prior to joining the bar, where were you employed?
I was with the National Prosecuting Authority at different levels, but when I left, my last day was 31 December 2013. I was a senior state advocate based at the office of the Directorate of Public Prosecutions.
So, for how long were you at the NPA?
From 1997 to 2013.
Could you just briefly take,
Would that be more or about 15 years?
2007, 8, 9, 10, 11, 12, 15, 16.
can you briefly take the chair to your career at the Department of Justice and or the NPA?
Before I became a prosecutor, I was a court interpreter employed by the Department of Justice from 1985 to January 1993. And then from February 1993, I then went to full-time study at the University of Zululand. In other words, I resigned from the Department of Justice effectively 31 January 1993. And then 93, 4, 5, 6, I was in full-time study at UniZul doing BProc. And then I returned to the NPA in 1997 as an aspirant prosecutor.
Well, I guess you came to the NPA because for the first time rather than returned, because before you were in the Department of Justice
Yes.
as an interpreter.
Yes.
You were coming to the NPA for the first time.
Accurately correct, Chair.
Yes.
I studied in the NPA in 1997.
Yes,
Yes.
okay, yeah.
In 2011, where were you employed?
I was at the office of the DPP as a senior state advocate. I was based in the Durban office.
And do you know who the DPP of KZN was at that stage?
At the time, it was Advocate Simpiwe Mlojwa. He was acting as DPP.
Now, if we turn to your affidavit at page 1, paragraph 4, you state that you were allocated a corruption case.
Yes.
So I'm sorry, Mr. Manyat. So you may have been at the bar for 6 years, but you have been an advocate for more than 20 years.
No, Chair. It's an interesting point. I never thought I would leave the NPA.
Yes.
So it was one of those mindset aspects that I don't need to be admitted as an advocate, because as a prosecutor, you don't need to be admitted. You can be, that's why it's called a state advocate.
Oh, well, I thought you are only a state advocate if you have been admitted as an advocate.
No, not necessarily. So
you can be a state advocate without being an advocate in terms of the Advocates Act.
Yes.
Because in terms of the Advocates Act, you are only an advocate if you have been admitted as an advocate, isn't it?
Yes, Chairperson.
Yes.
In the sense that the delegation and authority to prosecute is in terms of the National Prosecuting Authority Act.
Yes.
So you can be a state advocate without being an advocate in terms of the Advocates Act.
Yes. Oh, okay. No, I didn't know that. I thought you are called state advocate because you are an advocate employed by the state. Okay, all right. I learned something today.
Indeed,
Yes.
Chair. Advocate Maniati, when you Did you in fact receive this corruption matter?
Yes,
Did you peruse the police case docket?
I did.
Mr. Nicholson, you just said this corruption matter. I think you must specify what corruption matter you're talking about.
Indeed, Chair. I was going to come to it later, but I think it's an
For somebody who
appropriate
is reading the transcript to follow the evidence, they won't understand what this matter is.
Advocate Banyati, can you tell us who the suspects in this matter were?
The suspects were,
You still have this matter.
Yes, I'm coming to the explanation.
Why don't you go to it? It's not in dispute. Why don't you go to it straight away? It's the amigos matter or whatever, just specify it.
I'll answer that, Chairperson.
Yes, yeah, tell us what the matter is first.
The corruption related to the alleged bribery of General Johan Boysen, who was the provincial head of the Hawks
Yes.
at the time.
Oh, okay, that's the Pandey and Colonel Medu matter.
Yes.
Yeah, okay, all right. That's what I wanted, so that further questions as they follow, everybody understands which matter you're talking about, because there are various matters that have been covered today and yesterday.
Indeed, Chair.
Okay, all right.
Did you peruse the police case docket?
I did.
What was your impression of the evidence in the police docket?
There was a case.
Okay.
That is why I prosecuted.
Now, you mentioned the names of the accused at paragraph 6 of your affidavit at page 2 of RR3.
Yes.
What were the names of the accused?
Colonel Navin Madhu, as in a colonel in the South African Police Service, and businessman Mr. Toshan Pandey.
At page 2 of RR3, paragraph 5, you state that the corruption case relates to a case of procurement fraud.
Yes.
Who was the prosecutor of the procurement fraud investigation?
I'm sorry, before that you were asked the question what your impression was of the case, and you said there was a case. How strong was the case against the accused, in your view?
I'll borrow from what the chairperson said to the previous witness. I was sitting. At the stage of making a decision
Yes.
whether to prosecute or not, all you are required to look at is whether there's a prima facie case
Yes.
that warrants a prosecution, in
Yes.
respect of which the accused are required by law
Yes.
to respond. So there was a prima facie case.
There was a prima facie case.
Yes.
Okay, thank you.
Okay.
In fact, I may elaborate, Chair, that obviously investigation progresses.
Yes.
Even at the early stage, when
Yes.
I enrolled the matter, there was a prima facie case. As
Yes.
the investigation progressed,
Yes.
the evidence was supplemented.
Yes. So as the investigation went on, or in any case speaking generally, as the investigation goes on, the evidence might become stronger.
Yes.
And the case might become stronger against the accused.
Yes.
Or sometimes it can be weaker.
Yes.
Yeah, okay. Yeah.
To illustrate the point I'm making, ultimately, I drafted an indictment and indicted both accused in the High Court on a charge of corruption.
Yes, okay, thank you.
Okay. Who was the prosecutor in the procurement fraud investigation?
Miss Wendy Clark. Clark was her maiden surname. She then got married. I've got the married surname there, Grief, but we still called her Wendy Clark.
Okay. In which section of the NPA is she based?
I beg your pardon?
In which section of the NPA is she based?
Miss Clark was with the organized crime of the NPA, which fell under the general section.
Okay. And can you just briefly, do you know any of the facts regarding to the procurement fraud?
The facts would be based on what I was told when I consulted with the investigation team in the corruption matter, as well as Ms. Clark herself, I did consult with her. The reason I'm mentioning this is because I did not read the fraud case. I did not need to read it. So the facts, as I was informed, were that in 2010, when there was the Soccer World Cup in South Africa, police officers from all over the country were doing special duties, obviously at specific places where there were stadiums where the matches were going to be held. So you would find police officers being moved from their bases to these different places. They were doing special duties, and in the process, accommodation had to be obtained for them. And in the process of awarding tenders, for lack of a better word, I don't know what the procurement process was, but let me rather say, in the process of awarding the accommodation to the SAPS, it was alleged that companies, not one, companies that were owned by Mr. Toshan Pandey, he was a businessman, were awarded this procurement, so to speak, and the charges that were charged for the accommodation were overinflated. Hence, the 60 million rand fraud based on the overinflation of prices for these B&Bs, lodges, etc.
Okay. Do you, who were the suspects in that fraud case you just mentioned?
Again, as I was informed by my colleague and the investigators, it was the same two suspects, Madhu and Pandey.
Those people that you mentioned at paragraph 6 of your affidavit.
Yes, if I may elaborate so that the chair will understand. Madhu was in charge of procurement in KwaZulu-Natal. I think that is how he featured in the alleged fraud, because the procurement for the accommodation had to go via him. He was in charge of it.
Okay. At paragraphs 8 to 18, at Exhibit R3, page 3 and 4, you give a brief detail of the corruption matter. Is that correct?
Sorry, which paragraphs? Page 3?
It is pages 3 and 4, paragraphs 8 to 18. Okay.
Yes.
Who is the complainant in the corruption case?
Complainant was General Johan Boysen.
And how does corruption occur?
It was alleged that Colonel Madhu approached General Boysen.
I'm sorry. Please don't forget your question, Mr. Nicholson.
Okay.
Before you proceed, I just want to talk about your statement that General Boysen was the complainant. Yesterday, during Mr. White's evidence, a reference was made to either an email or a memo which was written by General Boysen, I think to the head of the Hawks at the time, where he was refuting the statement made by, I think, somebody from the NPA, I think Advert Litswalo, that he, or Advert Noko, one of the two or both, that he had been the complainant in that matter. And I think he said, well, he was simply a witness, and that I hope my recollection is correct. I think he said the complainant was the state, I may be mistaken about the second part, but he refuted any suggestion that he was the complainant. What would you like to say about that?
I'll answer as a lawyer and a former prosecutor. He was technically correct in the sense that it's a layman's perspective. I'll use the example of, say, my car is stolen. I go and lay a charge of theft of motor vehicle. I regard myself as the complainant, and in fact, the prosecutors, the police, and everyone would say I'm the complainant. However, in the sense that the ultimate decision whether to prosecute or not lies with the prosecuting authority. So strictly speaking, you could say the NPA is the complainant. More so, Chairperson, you have instances, I'll use sexual offenses, rape. You'd have many instances, even when I was a prosecutor, that the so-called complainant wants to withdraw a rape charge, and as a prosecutor you say, no, I'm not going to do it, because you have the authority in terms of law. So it's a matter of perspective. So Boysen was not incorrect.
Well, let's look at that. Using the term complainant in the normal way in which it is used within the context of criminal law,
Yes.
and within the context of crime and prosecution,
Yes.
would it be a legitimate or correct use of that term to say he was a complainant in the matter?
I don't know what his reasoning was.
Yes, but on your understanding of the term and on your understanding of his role in this matter, would you, if somebody says he was the complainant in that matter, would it fit within your understanding of what a complainant is generally understood to be in the context of prosecution and criminal law?
I would say probably not, based on the nature of the charge. It's corruption. He is allegedly being bribed in his official capacity as a policeman. So it's not a personal matter where, like the example of theft of motor vehicle, I've made the point. So he is just a witness in the sense that he's being bribed in his official capacity as a policeman. So he had a point to make. So he is correct.
Now, to the extent that either Advocate Nock or Advocate Letswalo may have, in one or more of their memos relating to the withdrawal of the charge, may have said he was the complainant in that matter, what would you say about their use of that term in saying he was the complainant? Would you be able to say, would you say that was a wrong use of the term? Would you say it was not a wrong use if you look at what is normally said, but technically it was wrong? What would you say about that?
It's a difficult one in the context of...
I just want to understand, because from the NPA side, when they withdrew the charges, one of the criticisms they relied upon to justify the decision to withdraw the charges was that General Boysen was the complainant in the matter, and yet he was playing a certain role, such as they said he was writing letters or giving instructions as to who could or could not visit or see Colonel Madu when he was in police custody, and I think they said something else. But the impression they were creating was there's something strange happening here. This man is a complainant in this case.
Yes.
And yet, look at what he's doing. He is in charge of what is happening. He says he will say who may see the accused and who may not see the accused. He should not be playing that role. That's my impression of what they're saying. And when he responded, he was saying, no, but I'm not the complainant. So I'm trying to understand the matter from their perspective. Is there somebody who was being disingenuous in the use of the word of the term, or in adopting whatever position was being adopted by the two sides? Or is this a situation where both could genuinely be thinking they were right in the position they were taking, and nothing more should turn on it? But the prosecution, the NPA, used that as one of the reasons to say there is something fishy here. For that reason, we are not going to prosecute. We are withdrawing the charges. For that reasons, and maybe and other reasons, we are withdrawing the charges.
I now understand, based on the information that the chairperson has given me, I was not aware why the charges were withdrawn, because they were withdrawn after I had left the NPA. And because it was in the public domain, I got to know, because certain prosecutors also called me out of interest to say,
yes,
are you aware that the case that you were allocated
Prosecuting
has been withdrawn on the instructions of the DPP advocate Nogo? To answer the question, as a prosecutor, I would not have given that reason if I took that decision to withdraw, to say I'm withdrawing because General Boysen is the complainant. No. I think it doesn't make legal sense. Perhaps one should also answer in an insightful way. Let's talk about the 60 million rand fraud, where the state, as in the Department of the Police, was allegedly defrauded. That who is the complainant? Is it the person who opened the docket, who is representing the police? Because someone has to open the docket. So let's say it was Captain so-and-so who opened the docket because a crime had been opened. No, it's not that captain. It is the police, the entire department. So from that perspective, I would say that there's substance in the perspective that Boysen was not the complainant.
Okay, thank you. I'm just thinking of other cases where a police officer witnesses a crime being committed, whether, unless there is somebody else who is a complainant, the police can't arrest and the NPA can't charge unless there is somebody who is called a complainant. What can you tell me on that? In other words, this thing of a complainant, must there always be a complainant?
No. Again, interestingly, practical cases that I've dealt with in my career as a prosecutor, way back in district court when I started, the police would go to the city, the CPD, and be in plain clothes and do what was called crime prevention against pickpocketing. I prosecuted several cases where, for instance, a pickpocket would pickpocket a civilian, and the civilian was unaware that he's being pickpocketed. That was the whole point of pickpocketing, that you take the wallet or
without
whatever.
the person being aware.
Yes, and the policeman would chase the pickpocket, and by the time he catches him, the victim, so to speak,
Is nowhere to
is
be
gone.
seen, yeah.
And we
yes.
would prosecute pickpockets for robbery of a person unknown to the state.
Yes.
And we would secure conviction
yes.
on the basis of the evidence of the policeman.
And you would not say the policeman who arrested the pickpocket is a complainant.
No,
Yes.
he's not a complainant.
Yeah, he's just a witness
He's just a witness, and because
to a crime.
he's a witness and the only one who witnessed the crime was available, he would then open the docket.
Yes.
On the part where it says complainant, his name would be there, Sergeant so and so, but he's not the complainant really.
Also, so in terms of paperwork, he or she might appear as the complainant.
Yes, on the face of each docket,
Yeah.
there's a part which says complainant.
Yes. Then you would put the policeman's name could appear then
Yes.
there. Would it ever happen that no name is put there, but the matter is prosecuted?
There would always be a name. A good example is cases of murder or homicide. In a case where someone has died, the complainant is always a policeman who opens the docket
Yes. Okay.
because the deceased is dead.
Yes. Okay. Okay. So this issue about whether General Poison was a complainant or not, maybe it's not a simple issue.
No, it's not. But,
Yeah.
but based on what the chairperson has told me
Yeah.
as being one of the reasons cited for the withdrawal, for me,
Yeah.
it doesn't make legal sense.
To rely on that.
Yes.
Okay. Thank you.
Advocate Maniati, you were still explaining to the chair how the corruption occurred?
Yes. The allegation was that Madu approached Boyson and offered him 1.5 million rand to predate a report which had been submitted in the fraud matter. Those were the brief facts, but I can elaborate further because it was something that happened over a period of time from the moment the approach was allegedly made by Madu, culminating in the exchange of the cash and the report.
When you say fraud matter, you're referring to the procurement matter.
Yes, Chair.
Okay.
I think it's appropriate if we can just go through it step by step. You said Madu approached
Boyson,
Boyson and offered him 1.4 million,
1.5.
1.5 million
Yes,
to predate a report.
yes. Which had been submitted in the procurement fraud case.
What is the significance of this report?
Maybe before that, the procurement case, the fraud case that you refer to, the suspects or accused were who?
The same two.
Mr. Pandey and Colonel Madu.
Yes.
Okay, all right. Then the question of what was the significance of the report that it was said he wanted predated.
Based on the briefing, it was called specifically a preliminary report in the sense that it was not final. The investigation was ongoing. A preliminary report was submitted to Boyson as the provincial head of the Hawks. That preliminary report, I was told, was not signed. And must I just
Yes, just continue.
unpack everything?
Unpack it, yes.
All right.
Yeah, but having said so, I think he was saying what was the significance of the report. So if you are able to just zoom in on that.
Okay. For the report to have been compiled, there are occurrences that happened. The sequence is critical. Investigation, as part of the investigation, the police, in conjunction with the prosecutors, would apply for what is called a Section 205 subpoena. Section 205 in terms of the Criminal Procedure Act. Must I elaborate on what it provides?
Not really, yeah, because there's been evidence, yeah.
So you then get a prosecutor to apply for the Section 205 subpoena, and a judicial officer authorizes it. In this case, the Section 205 subpoenas are served on financial institutions. I would presume banks, so that the banks would provide bank records of the companies that allegedly were paid from the procurement fraud. And it was alleged that those companies belonged to Pandey. So sequence is Section 205 subpoenas served on the bank or banks, depending how many accounts where they were held. Banks then provide bank statements. The police then look at those bank statements. Remember, the modus operandi is that the charges for the accommodation were inflated. And obviously the police would not pay those companies cash. There would be EFTs or whatever, so there would be a paper trail. Once you access the bank records of those companies that were paid, you then see how much was paid, on which day, for which accommodation, totaling how much. And then once you access those bank records, you then compile a preliminary report saying, at this stage, prima facie, there is evidence against Madu and Pandey.
No.
So, coming back to the question, the significance of that report. So the report, as I was told, was not dated. It was a preliminary report. I was informed that what was going to happen after that, the police would engage an external service provider. It was usually accountants and auditors firms, to conduct a forensic audit report. That would be the final one. Okay. Tell me if I've not answered your question.
No, you have. What is the significance? I didn't come out clear. What is the significance of predating the report?
The report, the significance is this. Remember the sequence. Section 205 subpoenas, bank statements, report. Also, it is important to mention that at some point, Pandey brought a challenge in the High Court to have the validity of the Section 205 subpoenas set aside. So he was challenging their validity. That is a separate civil matter. Now, if Madu approaches Boysen and say, predate this preliminary report, which refers to bank statements. Once you predate that report to prior to the date that the Section 205 subpoenas were obtained, it logically means the report was already completed before the Section 205 subpoenas were obtained, in terms of which the bank statements, which are referred to in the report, were obtained. So it would bolster the notion that the Section 205 subpoenas were obtained illegally, which would follow also that the bank statements were obtained illegally.
Okay. We have to take a very short break. Let's make it 5 minutes. We adjourn.
just stand here. Let me go to the gents.
Okay, let's continue.
Thank you, Chair. Advocate Maniati, if we go to RR3, page 4, paragraph 14,
I'm there.
you mentioned that Pandey's fingerprints were found on the report.
One print,
One print.
fingerprint, yes.
From whom was this report received?
What happened is, remember that Boysen already had a copy of the report, the preliminary report. So when Madu approached him to predate it, Boysen said he doesn't have a copy. Whether he was misleading Madu, playing along, I don't know. Or whether he had genuinely misplaced it, I don't know. In any way, Madu then said, I will provide you with a copy of the report. Just to digress a bit, when we were busy with the bail application in respect of both Madu and Pandey, because we opposed it as the state, I nearly said I opposed it. It was common cause that Madu had a copy of the preliminary report on his own version. So Madu said, I will give you a copy. And
Just
then,
to recall again, that would have been a report prepared by the investigators.
yes, in the fraud matter.
Yeah, in the fraud matter.
Yes.
And it being a report to whom?
As I understood, I don't know whether to Boysen as the provincial head of the Hawks in KwaZulu-Natal or to the national head of the Hawks.
Okay.
I think it was General Dramat at the time.
Yes, yeah.
I'm
so
not sure.
It was one of them.
Yes.
It would have been a report to either General Boysen or to the head of national head of the Hawks.
Yes.
That's your recollection.
Yes, but both would have a copy of it.
Yeah,
Whether
okay.
whether it was addressed to Boysen or Dramat, the one would give the other, or it would be
Yes.
given to both.
Yes. So was your understanding that Madu was not supposed to have a copy of this report?
I don't know.
You don't know, but
I don't know.
It was common cause during the bail application that he had a copy.
Yes.
Yeah.
It was common cause. Based on the fact that it was common cause, again, this is just my reasoning. It's not based on any facts that were before me in the docket. Remember, Chairperson, that the procurement fraud emanated from the accommodation, and I said Madu was in charge of procurement. It could be that as the head of procurement, in whose section this fraud occurred, was given a copy of the report.
Yeah. Okay.
Yeah. So he then said to Boysen, well, I've got a copy, I'll give you. So he gave him. And Boysen did not predate that one that Madu gave to him, because it was taken for investigation. That is where Pandey's fingerprint was found. It was found on that report.
Oh, okay.
And it was then preserved as evidence.
Yes.
Because fingerprint elimination had been done on it, so it was now evidence.
Yes.
So what then happened, I'm just completing the picture. Now that Madu has given him a report, Madu is unaware of the developments now that Pandey's fingerprint has been found. Subsequently, then Boysen gave Madu a predated report. I don't know where that report came from. Boysen can answer. Either Boysen made a copy of the report that Madu gave him before it was submitted for fingerprint or afterwards, or Boysen drew his own report that he had initially said he doesn't have anymore.
Yes.
So
Yes.
the predated one was then handed to Madu.
Okay. Okay. I didn't hear that before, so I think I'm hearing that for the first time.
Yes.
Okay. So there was a predated report that General Boysen gave to Madu, as you understood the position.
Yes.
Yes. Okay.
Yeah. The exchange occurred on the day that Madu was arrested. So what happened is...
Oh, okay.
As I said, it was over different days, culminating in the day that the sting operation was held. So Madu gave Boysen 1.362 million He had offered 1.5,
Yes.
but gave him 1.362 million, and then in exchange, Boysen gave him
The
a predated report.
Okay. Okay. Maybe I was told about him giving General Poison giving Colonel Madu a predated report. Maybe I've forgotten. I've been hearing too much evidence. So, yeah.
Do you know, dealing with the report with Pende's print on it, where is that report now?
As I said, the report on which Pandey's print was found, after that print was found, it was preserved as evidence. So it was not in the docket. I now recall procedurally, when a fingerprint expert does an elimination, they keep the exhibits. So it would have been preserved in the safe or strong room of the local criminal record center where the fingerprint expert is based. But the fingerprint expert would depose to an affidavit for purposes of filing in the docket, setting out everything.
Okay. If we go to RR3, page 4, paragraph 15, you mentioned that authorization was received in terms of section 252, capital letter A.
Yes,
Which act are you referring to?
Criminal Procedure Act.
What is the significance of section 252, capital letter A?
In essence, the section says before a trap is conducted, the police must obtain authorization from the Directorate of Public Prosecutions to conduct that trap. Obviously, there are exceptions, like any other provision.
Okay. So you mentioned that a sting operation took place on the 8th of September 2011.
Yes.
Okay.
I guess its significance is simply that it's a measure, obtaining the authorization beforehand. It's a measure to ensure or distinguish, at least at a general level, between a legitimate trap and something else that's not really a legitimate trap. In other words, if you find, if General Poison, if while General Poison was with Colonel Madu and Colonel Madu was handing over the cash, if there wasn't this kind of provision, if later on the police charged both Madu and General Poison, and General Poison says, no, it was a trap, it would be difficult to know, is it genuine, is it true, or was he also engaging in some illegal activity? But now in order to get out of that, he says, no, as a police officer, it was a trap.
Yes.
If you have gone to the NPA and said, I'm asking for authorization to conduct a trap, if you are caught in that situation by the police, you can say, go to the NPA, you will find that this trap has been authorized, I asked for it. Then in that way, you avoid a situation where the police can get involved in illegal things and claim that they were conducting a trap.
Yes.
Yeah, okay.
Now, was there a section 252, capital letter A, authorization for the sting operation that took place on the 8th of September 2011?
According to the evidence in the docket, there was authorization.
Okay. Now, you have spoken about the sting operation. Can you just tell us where did the sting operation take place?
If I recall, yes, I remember now. Both Madu and Boysen were based in the office of the provincial headquarters of the police in Durban. the operation occurred in the basement, in the parking lot of that building.
Was it during this sting operation that the 1.3 million was exchanged?
Yes.
That you mentioned earlier.
Yes.
Can you just, do you know where the money was found after the exchange?
It was found in Madu's car. Sorry. It was found in Poison's car.
Okay. And the predated report, was the predated report ever exchanged?
Yes, it was found in Madu's car.
Okay.
I'm sorry. What was found in Colonel Madu's car? What was found in General Poison's car?
Initially, I got it the other way around. The money, 1.362 million, was found in Poison's car, and the report was found in Madu's car.
Oh, okay. At the time of the arrest.
Yes.
Also, so Colonel Madu had succeeded in transferring the cash from his car to General Poison's car.
Yes.
Yeah, as you understood the position.
Yes. If I remember the specifics, they arranged to meet at the basement in the parking, and then Poison said, "Come to my car." So Madu entered, he gave him the money, and then he gave him Poison gave Madu the report, and then Madu walked to his car. Once he entered, the police officers who were at strategic spots then arrested him on the spot.
Do you know if the sting operation was recorded in any way?
If I remember correctly, there was an audio recording.
Now, we know that 1.362 million was given to General Poison. What was the benefit to Madu, who gave General Poison this money? You have mentioned it, if you can just crystallize it.
Benefit in what sense?
What did he get this money
Maybe,
for?
yeah. I think, the question would be, why did Colonel Madu give General Poison such a lot of money?
So that, as initially asked, so that Poison would predate the preliminary report.
Now, if we go to paragraph 17 of RR3.
So in other words, he was buying him, so to speak, buying him to do this for him.
Yes.
Okay. That's the normal language.
Yes.
Yeah, it was an inducement. Yeah, okay.
If we go to page 4 of RR3 at paragraph 17, can you just read, it will be apt if you just read that paragraph?
17.
Yes.
Madu admitted after his arrest that the cash that was handed over to Poison had been provided by Pandey,
How do you know this?
because it was in the docket, as in the evidence of the members of the sting operation, who I can't remember.
Made statements?
Yes, they made statements.
Yeah.
Yeah.
Okay.
Okay.
So you had, when the docket was before you, you had the report that had Mr. Pandey's fingerprint,
Yes.
and then you had statements by members of the investigation team who said Colonel Madu said to them after he had been arrested that Mr. Pandey had provided the cash that he gave to General Poison.
Yes.
Yeah.
An interesting point of law, because there have been developments. At that time, an admission was admissible against another person as in a co-accused. The law has changed.
Chair, the chair asked my very next question. What was the evidence against Pandey? Because in page 5 paragraph 18, you stated that you applied for a warrant of arrest for Pande.
Yes. The chair has summarized the two main aspects that I considered. Of course, there were other circumstantial aspects that I applied my mind to. What motivated me, or rather what informed my decision to say there's a case and I am going to apply for a warrant to have him arrested, I was mindful that, you know, if I was having him arrested unlawfully, I could be sued. So a fingerprint is found on a report which is strictly supposed to be within the police service. He's not a policeman, he's a businessman. What is this fingerprint doing on a report? Two, the person who provides the 1.362 million makes an admission that, sorry, the person who gives Boysen the money makes an admission that Pande provided the money. Obviously, in my head, as I said, you also look at other circumstantial aspects without undermining him, but I considered the probability that a colonel in the police would have so much money.
And you had also mentioned that
I'm
Pande-
sorry, the point you make is that it was unlikely that a colonel in the police would have so much money to give to somebody else.
Yes.
Yeah, okay.
Okay. And you had also mentioned that Pande was a suspect in the fraud matter.
Yes.
Do you know if Pande was ever arrested for this
For the corruption?
Well,
Yeah.
firstly, did you get the warrant?
I got it.
Yeah, okay. Was it carried out?
It was executed and they arrested him.
Yes, yes, okay.
And I enrolled him.
Okay.
In other words, I added him to Madu, who was already accused
Yes,
on the roll.
yes.
At the time you arrested Pande, at that point in time, what was your estimation on the prospects of a successful prosecution in the corruption matter, in this corruption matter we're dealing with?
As I said, I ultimately indicted both in the High Court, so there was a case. Very good case, in my view and experience.
Okay. You had also mentioned that you were allocated this matter by the acting DPP,
Yes.
Advocate Mlochwa.
Yes,
Did you keep him appraised of the progress in the prosecution?
I did.
Did he ever express any reservations to you regarding the evidence?
No.
At RR 3, page 5, paragraph 19, you say that representations were made to Advocate Lawrence Mkhwebi, the National Head Specialized Commercial Crime Unit, known as the SCCU.
Yes.
Perhaps it's convenient if at this point you can just explain the structures within the NPA.
I'll deal with the two units that are relevant here. You had, it still is the case, so I'll speak in the past tense. You had the National Prosecution Services, which was called NPS, under which all the offices of the DPPs in all provinces fell. And in terms of hierarchy, under the DPP, you would have the Deputy Directors of Public Prosecutions. That's in terms of the High Court. And then on the side, still falling under the DPP, you have Chief Prosecutors who were in charge of clusters. Clusters are made of districts. And then under Chief Prosecutors, you have SPPs who are in charge of districts. And then your prosecutors at below that. That was the NPS, which was called the General Section, under which I and Ms. Clark fell. And then on the side, you would have the Specialized Commercial Crimes Unit, the SCCU. The national head of SCCU, who was based in Pretoria, was Advocate Mkhwebi. And then SCCUs would have offices and courts in major centers. For instance, in KwaZulu-Natal, the entire province, there's one SCCU office and court that would be in Durban. There were, other offices and courts in major cities like Johannesburg, Pretoria, Cape Town.
So the point is the NPS didn't fall under the SACU, but it was a parallel structure.
Yes. If I may elaborate something important, when advocate meant all along, there were just two separate structures in the sense that the one hand did not know what the other hand was doing until Advocate Menzies Melane became the National Director of Public Prosecutions, and he changed. So when he came on board, he said he doesn't want a situation where, for instance, I'll use KwaZulu-Natal, the DPP, in this case Advocate Mlojwa, is in charge of the whole province, but he doesn't know what is happening at SCCU, which is situated in Durban within his province. He said, no, there should be two centers of power in terms of SCCU. The DPP must be involved, and so is the special director who sits in Pretoria, in this case, Advocate Mkhwebi.
Okay. In which section did you and Advocate Wendy, I think you said it's Maiden Clark, work?
General section, NPS.
And under which section did both the fraud and corruption prosecutions reside?
The fraud matter, I don't know whether it was ever enrolled, but at the time, it was not on the roll.
Okay.
Remember, I said there was still a long way to go. There was still going to be a forensic audit report, etc. So it was not on the roll. It was still being investigated. The corruption matter was under the general section. But that's one aspect where I said I need to add. It actually came back to my recollection as I was sitting there. Initially, this corruption case was held at the Commercial Crimes Court, and then it was moved to the General Court, which would be Durban Regional Court. But it was allocated to me by Mlojwa, who is in charge of the general section, and also technically in charge of SCCU, and I was in the general section.
Okay. Did it make any sense for representations to be made to the head of SCCU and not to the acting DPP KZN?
It's the point I make in my affidavit. I'm just saying I don't know why the representations were made to Mkhwebi. That is as far as I can say.
Hang on, hang on 1 second. Did corruption matters not fall under his unit, or they did? Fraud and corruption?
Under the specialized commercial crimes unit.
No, they didn't. They were under general.
Fraud, yes, certain frauds.
Certain types of
fraud
would fall under his unit.
Yes, complex frauds.
Complex fraud, commercial fraud.
Commercial fraud, more precisely, because
Yes.
we also, in the general section, we did a lot of fraud.
Yes.
Very serious fraud.
Yeah.
I did many.
Yes. Okay, so commercial fraud would fall under his unit.
Yes.
But there would be a lot of other fraud cases that did not fall under his unit.
Yes.
And those would fall under general section.
Yes.
And corruption, would there be some corruption cases that fell under his unit? Or you are not sure?
If you look at the very establishment of that specialized commercial crimes unit, I don't think they were dealing with corruption.
Yes.
Yes. I mean, by definition. But
well, unless I guess they wouldn't separate it if the fraud is part of corruption.
Probably, yes.
If it's commercial fraud, but that commercial fraud is part of corruption, then maybe it could fall within
Yes.
that type could fall within his unit.
Yes.
Yes. But this particular fraud, would it fall under commercial fraud, this kind of case or not?
I don't know, but something important, Chairperson, as I've said, I only recall this morning as I was sitting there that when I first went to court for this matter, we appeared at the Commercial Crimes Court, and then it
Okay.
was moved to Durban Magistrates Court, which is in a separate building.
Yes, okay.
Now, the representations that we refer to are at page 12 of R3, attest to your affidavit as BM1.
Yes.
If we look on the same page, at the second unmarked paragraph, can you read the first line?
Which paragraph?
On the same page, the second unmarked paragraph. Starting from, well, both of them start from we, the second we.
The one that says we are instructed.
That's correct.
Read the entire one.
Yes. Well, read the first line.
We are instructed to make the following representations to your offices as our client is of the reasonable belief that your offices have clearly not been appraised of the circumstances wherein our client is a potential witness in matters of national interest involving both provincial and national levels of SAPS management, intelligence, covert operations, the Hawks, and others.
Okay. It was just the first line that I was interested in. We are instructed to make the following representations to your offices. Now, on whose behalf were these representations made?
Interestingly, the attorney is present here. They were made on behalf of accused number 1 only, Madu.
Okay. Now, what do you make of the line there that you read, the first line?
In what sense, Mr. Nicholson? I'm just
Well-
reading this as an attorney saying to Mkhwebi, I've been instructed to make representations to your office.
To your offices, yes.
Yes.
My reading is that Colonel Madu advised his attorney to make representations to Advocate Mkhwebi's office and not to your office.
I wouldn't want to go that far because I don't know. I was not privy to the discussions between Madu and the attorney.
Yeah, I'm not sure that I follow what you are talking about. Of course, when that sentence says we are instructed, written by an attorney, it means our client has asked us to do A, B, C, D. So we are instructed to make the following representations to your offices. The reference to your offices is the reference to the offices of the national head of the Special Director of Public Prosecutions in Pretoria. So I'm not sure that I follow what the issue is.
Chair, the point that I was trying to establish was my reading of that line is that instructions were given to make representations to the SCCU's offices and not to the DPP's offices where the representation should have been made. But Advocate Manyati has stated that he doesn't see it that way.
Oh, okay. Well, I don't know, maybe the two of you are talking at cross purposes. Well, the letter is addressed to Pretoria, to the national head of the Special Commercial Crime Unit. Obviously, when the author of the letter says we are instructed to make the following representation to your offices, that is the offices of the national head in Pretoria.
Advocate Mkhwebi.
Yes.
Specifically, yes.
Yes. That's what you also understand it to be saying.
Yes.
Yes. There is no confusion. You are both on the same page, but I thought it looked like you were not on the same page.
Perhaps the difference, Chairperson, is this. Mr. Nicholson is saying is reading into that to say we are instructed to make representations to you, Advocate Mkwebi, and not to Mlojwa. It's the latter aspect that I'm saying I'm not willing to go to that extent.
Yes, but that's not what the letter says, isn't it?
One could read the letter in that light.
Let me see, maybe I'm missing something. We're instructed to make the following representation to your offices, as our client is of the reasonable belief that your offices have clearly not been apprised of the circumstances wherein our client is a potential witness in matters of national interest involving both provincial and national levels of SAPS management, blah, 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 blah. What they may be saying is, they are saying definitely we are approaching you at national level. That is now specialized commercial crime unit. And then they seem to be saying, the reason why we're approaching you is that you might not have been appraised of the circumstances wherein our client is a potential witness in such and such a matter involving the provincial and national levels of SAPS. I'm not sure that I see what the point is. I'm not sure.
Indeed,
If the point is they were supposed to make representations somewhere else, that might be a separate point, but I don't see that from that paragraph they are necessarily saying we have a particular reason for not sending it to the provincial office.
Chair,
I'm not sure if it's important, but you tell me if it is important to understand.
Chair, no, Chair. I think we can leave it and continue.
Yes, okay.
That same paragraph mentions that our client is a potential witness. Can you see that?
Yes.
Do you know if it's a witness in any matters of national interest?
I don't know. In fact, in my memorandum in which I responded to Advocate Mkwebi's covering memorandum wherein he attached these representations, I said Madu is clouding issues. Though most of those aspects that he's talking about, I was not privy to. They did not feature in the corruption matter, so I don't know what he was talking about.
It was just statements which were not substantiated. He
Yes.
didn't put up anything to say what he was talking about when he was referring to matters of national interest.
Yes.
Yeah.
Also, the key word he said, he's a potential witness, not as if it's actual.
Yes, but potential witness or not, these national matters of national interest he's referring to, he didn't put up any facts
No.
to tell you what he was talking about.
Yes. No,
yeah.
he didn't.
Okay.
During this time, you had already mentioned that Madu was was a suspect in the fraud matter.
Yes.
I see we are at 5. What's your estimate of how much time we need?
We're about halfway, Chair.
Without,
We're about halfway.
we're about halfway. We won't get to the next witness. Huh?
No,
Yeah.
it seems not, Chair.
Okay, I think I'll go up to 5:30. Let's see if we can finish. Will that suit you in terms of going back?
Now that the chair has asked, I'll say it. I didn't want to spoil the record.
Yes.
My flight is at 7, which means I'll have to check in at 6. I don't know. Johannesburg has a reputation of traffic.
Yes.
I don't know
Yeah.
what's the latest I should leave here with the traffic to check in at 6.
Yes.
And there's no flight
it
after
could be
7.
bad, yeah.
Malana Flynn has just indicated
Yeah.
that if he misses the flight, we'll put him on another flight.
But he says there is no other flight after that.
Chairperson, that's based on what Mr.
Yes.
Nicholson said.
Told you previously.
That is
Not
correct.
told the chairperson.
Oh,
That is correct, Chair. I did mention that the
Yes.
administration staff had indicated that there's only a flight at 7, and that's the flight we booked Advocate Maniati on.
and that remains the position,
Chair.
as far as you know.
That remains the position as far as I know, and anything
The-
has changed.
Sorry. The other option is this,
Yeah.
which I'm willing to sacrifice, but it's a sacrifice in the real sense of the word. I have a matter at Ulundi Regional Court tomorrow.
Yes.
There's no way I will not be there. Worst case scenario, if the commission would hire a car for me to drive to Durban, I'm willing to sacrifice and leave it at Durban,
Yeah.
at the airport.
Yes. Look, I think that's a good gesture, but I think we might not finish in 30 minutes' time. I'm saying that because Mr. Nicholson, I think probably you and I are quite poor in estimating anything. Because you had said you thought we might finish both witnesses within 1.5 hours.
Certainly, Chair.
So I think what we should do, we should stop. Unfortunately, and allow the witness to catch his plane, and then request that he should come back on the same day that the other witness must come back, so that we can deal with matters properly. Now, the other witness, that is Colonel
Deploy? Pete
Deploy, yes. I don't know whether I can ask for your estimate again of how long he might be.
Colonel Deploy is definitely going to be longer than
Yeah.
Advocate Maniati.
Yeah, we might have to find another time to bring them in. Next week, there are no witnesses who will be heard by the commission, because that's the week that had been reserved for the former president to come and give evidence. So one possibility is to find a day next week when then they can come back, or to find another date not too far from now. So I think what should happen is, let's adjourn. Before he leaves, before they leave, you get information about possibilities. Don't confine yourself to next week. Also look at later in February or early March, but also next week, because I'm not sure. It may be that we can use one of the days next week, or it may be that we should rather put it later on in February. Would that be fine? Would that be fine? Yes. I think let's do that. Let's allow him to catch the flight, because, as I say, I also didn't want to go beyond 5:30, and we might proceed, and at 5:30 we are not done, and then and when he drives all the way, he would arrive in Durban after 12 midnight, and then he must still drive from Durban tomorrow morning to where? Ulundi.
I should be leaving Durban at 5:30.
So I think let's rather stop now, and then you make those arrangements, and then you'll come back to me, and then I'll fix a date for them to come back. What about, when was Avem Lodwa to come? Because maybe he could come then too.
The Chair, as I understand the position was, Advocate Mlocho was supposed to come in this week,
Yes.
but because the law enforcement team had to give some of our times away, a date has not been set for him.
Yeah, no, that's fine, but he's ready in terms of you have the statement.
Yes.
You have the statement. It's a question of fixing a date.
We have the statements.
You've got the statement.
I believe the three notices have been served.
Oh,
So,
okay.
yes.
That's fine. I just wanted to have an idea. Later on, you can tell me what the position is afterwards, and maybe tomorrow, and then I can fix a date. But I think that's fine for today. Let's allow Mr. Manyata to catch his flight. So we are going to adjourn the proceedings. Discussions will be had to arrange another date, and we'll ask you to come back. Okay. So we are going to then adjourn. We adjourn for the day.